Any mention?
Yes.
May I please, Your Lordship, I beg to mention item 5, 6, and 7.
Item?
5, 6, and 7.
Item 5.
That matters, Your Lordship.
Yes.
Should I bring for 2 weeks' time?
There's no objection, Your Lordship.
At the request of the petitioner. Yes.
15.
May I please, Lordship, I beg to mention item number 15, my lord.
Yes.
Due to some personal difficulties, my lord, maybe
No objection, Your Lordship.
This also same. When do you want?
after 2 weeks, my lord.
Same order.
Lordship.
Oblige, Your Lordship.
Much praise, Lordship.
Yes.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 3, Your Lordship.
Yes.
Lordship, I pray for 2 weeks' time, Your Lordship, as the learned DIGI is on leave, Your Lordship.
Who is the other side?
Sajha, Your Lordship, prior consent has already been sought, Your Lordship.
Who is the parent mother?
Sajha,
So you want it after?
2 weeks, Your Lordship.
Okay, number 3 at the request made on behalf of Dr. Majika London DSGI, list of 2 weeks. Yes.
Similar prayer for item number 13 as well, Your Lordship.
13 and
13 only, 3 and 13, Your Lordship.
yes, Mr.
I don't have any objection.
Yes, 13 also. Same order. You are. Is the respondent?
Yes, Your Lordship.
Yes.
Much obliged, Your Lordship.
Obliged.
Please, Lordship. Lordship, beg to mention item number 8, appearing for private respondent number 2, Lordship.
Yes.
Can you allow after 3 weeks, Lordship, as conducting counsel will not be here for the next 2 weeks?
Yes. Who is for the response? Yeah. Who is the
My
one?
lord, I will pay for the petition, my lord.
Yes, Mr. Siddiqui. The respondent is asking for time.
My lord, in the meantime, yes, in the meantime, my lord, I may be allowed to submit my rejoinder to the affidavit. They have been raised many
This
points.
is a
which
criminal
needs to be
revision.
refuted,
This is
my
a criminal revision. What rejoinder is it? We'll,
But the thing is that they have gone beyond the material.
we'll see it. We'll see it.
Lord.
If they go beyond that, we will not entertain that. We'll just see at the time of hearing. We do not want to convert into a writ petition.
Only few points are there, my lord, if I may be allowed to raise.
That we'll see. Just let the matter be hard first. Then we'll see if required. Then we'll allow you.
Okay.
Lordship.
This when do you want it?
After 3 weeks, Lordship.
You're applying for respondent number?
2, Lordship.
Yes. Yes. This is the request for the respondent number 2. List after 3 weeks. Yes.
May it please, Your Lordship. Your Lordship, I beg to mention item number 10, Your Lordship. 10, 11, and 12, Your Lordship. Your Lordship, my humble prayer, Your Lordship, that the matter may be listed after 3 weeks, Your Lordship.
Objection. Yeah. No objection. After 2 weeks.
3 weeks, Your Lordship.
Okay. 10 also at the request of the petitioner. Yes. 10, 11, 12.
10, 11, and 12, Your Lordship.
But you are there for the state in all the cases.
I am there in 11 and 12, my lord.
I'm in item number 10 also.
Much obliged, Your Lordship. May I please, Your Lordship, I beg to mention item number 14.
Yes.
Let the matter may come up after 2 weeks, my lord. Because the conducting counsel
Sarah.
is out of session.
No objection, Lordship.
2 weeks of the request of the petition, item 14. Yes.
Obliged.
So I'd like to make mention for item 4, Your Lordship. So I'm
Yes.
praying for 2 weeks time, Your Lordship.
That is that defaulter.
Willful to default.
Willful defaulter matter.
So, yes.
No objection, Your Lordship, because I believe his mother is not well. So.
Senior conducting counsel.
When do you want it?
2 weeks, Your Lordship.
Yes. For item 4 at the request of the petitioner. Yes.
Really obliged.
Yes.
Daily cause list, item number 1.
Yes, Mr. Sangma, what is this?
Yeah, please, Lordship. Lordship, this is the case coming under 482. Lordship, what happened? The fact of the case here is, Lordship, the complainant was beaten up by the private respondent. He was beaten up by the private respondent. Thereafter, FI has been registered. There are 4 eyewitnesses. The eyewitnesses also I have mentioned the headman and 3 other from the villages and his wife. And then what happened?
May I submit, Your Lordship?
Yes.
Lordship, regarding this as to whether the CRPC will be applicable or the new CRPC will be applicable, Your Lordship, that question is to be decided by the division bench on 29, Your Lordship. Because in one of the keys, criminal appeal, that is alloy.
Do you have that? What is that new law?
Lordship, I don't. Section 531, Your Lordship.
I think.
Section 531, Your Lordship. 531, Your Lordship. What happened, Your Lordship, in that criminal appeal of Aloy Suyam? A conviction was the appellant was convicted under the IPC. They filed the criminal appeal under the new CRPC. So objection has been raised by the state. I was in the Lordship. Lordship, initially division bench agreed, but some of senior counsel, Mr. Poe and Mr. They would like to say to make a submission on that point.
There's a decision by Punjab and Haryana High Court.
Lordship, Delhi High Court, Lordship, there are contradicting among the 2 judges of the Delhi High Court, Lordship. Then Punjab and Haryana High Court say yes, the new BNS will be applicable. That was being followed by the Kerala High Court. Rajasthan High Court say no, Your Lordship. So there are conflicting judgments. I have those judgments, Your Lordship. I have if this matter come tomorrow, Your Lordship, I'll place all those judgments. But that issue, so far the state is, so our High Court is concerned, that will be taken up by the division bench on 29, Your Lordship. So in that view of the matter, if Your Lordship is pleased to
There is no urgency in the matter. Your
to
Lordship,
keep this matter on 29, Your Lordship. Maybe I'm sorry,
no, it's all
Lordship.
right.
Maybe my friend is not.
No,
aware
because
of
he is assisting us, so there is no problem in that.
No, but then why should there be an issue for that?
There are conflicting,
Old matters should be
conflicting
guided by
views
the old. Why? What is the question of application of law?
of the new law.
Lordship,
What is the
because a submission has been made on that words, Your Lordship, pending.
Because the FIR is dated 5/4
under
of
the
last year.
BNSS, Your Lordship, section 531 of the BNSS.
But the incident happened prior to the BNS, because it is happened in the
Whether
year
new
of
code will be
2023.
applicable or the old code will be
IPC
applicable.
was
So
also
it-
is the
that is yet to be determined. So, Your Lordship, if for judicial propriety, Your Lordship, if this matter can be on 29, Your Lordship.
Then it should be listed after the 29th.
On 20.
That means it has to come up after a week at least.
Lordship, yes.
Shall we pass an order, simple order? Shall we record that it has to be decided here?
I just simply adjourn, Your Lordship. We'll inform accordingly, Your Lordship. We'll inform Your Lordship accordingly because I was there in that criminal appeal.
Okay, at the request of the parties, list of priority.
There's going to be some confusion initially, Your Lordship, as
But
far
then
as
it
this
should
thing
not
is
be. I do not know. Is it not something?
Lordship, in
There
fact,
should not
you
have
think it is-
been,
do you
because
think it is
when the
very necessary?
FIR was lodged in 23, year
Of course,
it
2000.
should be
whatever it
covered
is
by
by-
the it should be covered by the CRPC, Your Lordship. So,
That is
so
what
far,
normal
my understanding of the law is concerned, because these are pre-July 24, Your Lordship.
See, Mr. Shulai.
Lordship,
See,
yes.
any cause of action under which proceeding is initiated, sought to be initiated. If it takes place before coming of the new, it has to
Certainly,
be
Your
by
Lordship.
these things.
Lordship, yes.
Doesn't matter.
Lordship, that was
Even
my
if police say supposing,
Lordship.
if an FIR is lodged on 30th June, it registered under IPC. Okay,
because
that
of-
proceeding should
because
go
of this
IPC.
because of this conflicting judgment of Delhi High Court, Punjab, and then Kerala High Court,
should
and
be
then
settled
Rajasthan
once
High
for
Court, Your Lordship. I have those judgment with
We
me.
have seen this Punjab and Haryana High Court.
This-
that
Yes, BNSS, Your Lordship. That is being followed, as I have said, Your Lordship, by the Kerala High Court. Rajasthan High Court say no. Then Delhi High Court, they say question left open. One say BNSS.
So let us see what our High Court says.
Lordship, yes. All right, Your
We are
Lordship.
bound by a high court.
Then item 2, Your Lordship. Item 2 also same, Your Lordship. Item 2 also will.
Who is appearing in item 2?
From the list, item number 1.
Match with the lordship. Match with the lordship. The instant appeal has been preferred against the interim judgment and order dated 31/12/2022, passed in WPC number 128 of 2017, Your Lordship. The background of the case is that, my lord, the appellant, along with 1,338 employees serving in the clerical cadre, Your Lordship, they approved this. Initially, they approved this honorable court, Your Lordship, through WPC number 277 of 2010, saying inter alia for grant of equal rank, status, and pay at par with other central police organizations by introducing the rank and status of warrant officer at the entry grade in the grade pay of 1,320 2040 with effect from 1/1/86. As applicable to the personnel of clerical cadre serving in PSF, CRPF, and also.
Who is on the other side, sir? Who is on the other side?
Yes.
My lord, Mr. Devnath.
Yes. Yes, Lordship.
Yes.
Your Lordship, here this pay and desk structure, whatsoever the petitioner is reading here, it is not correct, Your Lordship. Whatsoever this regular pay and others, it has been given as per fifth pay commission. Your Lordship, he is asking the rank.
Where is your reply? Objections?
This judgment, the earlier judgment had attained finality. It was carried on appeal before the Honorable Supreme Court. Lordship may look into the Honorable Supreme Court judgment, page 128 of my writ appeal, page 128. Honorable Supreme Court passed a detailed order, speaking order. Lordship will 128 of writ appeal.
So, shall we hear it in person?
My lord?
Shall we hear it in person?
Better, my lord.
Yes.
My lord.
What's the matter for hearing? I'm hearing. So, are you ready on the other side? Do you want to know? So, respondent is ready?
Mr. Devnath.
Yes.
Sir, not audible. Am I audible?
Yes, Your Lordship.
So, you ready, sir? Respondent?
Yes, sir.
Yes. Both parties are ready to have this argument. Pose the matter on so and so date for final hearing. Yes, sir.
My lord.
Yes.
Matter was heard, my lord, on the last occasion also. It's only on the ground that, my lord, whether if any witness who has already been examined, my lord, to what extent he can be examined, my lord. That has fallen from your lordship, my lord, on that issue.
The query was that,
My lord,
but what is the difference of criteria
my lord,
if it is concerning
my lord.
a fresh witness
And
if it is a person who has
it's
already
been examined, my lord, yes. My lord.
Is there any difference? Is there any decision?
My lord, I have come across one judgment, my lord. Lordship, if I may place it, my lord.
What does it say? Just if it is relevant, then you just say.
It say, my lord, if I may be allowed to read, my lord, the operative portion. Now it says, insofar as recalling and re-examination of any person already examined is concerned, the court must necessarily consider and ensure that such recall and re-examination of any person appears in the view of the court to be essential for the just decision of the case. Therefore, the paramount requirement is just decision, and for that purpose, the essentiality of a person. My lord, it says, my lord. No, my lord, it says that the essentiality of a person to be recalled and re-examined has to be ascertained. It says that it has to be ascertained. That is there, my lord.
Just give me that decision. Yes, which paragraph would be relevant?
Para 14, my lord. Para 14, the last paragraph, my lord. Last part, my lord.
Yes.
From the bottom, ninth line.
Yes.
Insofar as the, my lord has got it.
Yes, insofar as.
Insofar as recalling and re-examination of any person already examined is concerned, the court must necessarily consider and ensure that such recall and re-examination of any person appears in view of the court to be essential for the just decision of the case. Therefore, the paramount requirement is just decision, and for that purpose, the essentiality of a person to be recalled and re-examined has to be ascertained.
Now, if you say essentiality of a person
My lord.
to be ascertained,
My lord.
that means some reason.
Reason has to be given, my lord, by the prosecution.
In the present case, it is not there.
It is not there, my lord. The application, neither the application nor the order, my lord, says about any reason, my lord.
Yes, Mr. Groom. Anything else you want to say?
No, my lord. That's my humble case, my lord.
My lord, I have nothing more to say.
What did you say? The court has forgotten.
My lord, as rightly pointed out by my friend here, my lord, just decision of the case, my lord. Now, my lord, my respectful submission would be the order passed by the learned court below, my lord. Though cryptic, my lord, but here's the court below has reflected, my lord, that there is a necessity, my lord.
That is so. It's a.
It is there.
It is see just decision. So that
Right.
is always there.
Right.
But then how? What is the thing? Why this witness is relevant for this?
But that will be clear, my lord, unless and until he is allowed to be.
That is not mentioned here.
No. Unless and until he is allowed to be.
Okay. Anything else?
No, my lord. My lord, I am that apart, my lord, I am relying on one of the judgment, my lord. This is a case of V.N. Patil, my lord, 2021, where it says, my lord, at para 23, my lord, it is not necessary that in every case it is required to record elaborate reason.
We are not talking about elaborately. He just gave a reason. You see, just if you say that is somebody is needed for just decision, somebody is needed to be examined for just decision. Now, is it at all constituted reason? We can understand what is reason and what is elaborate reason.
My lord.
What is the decision you are relying upon?
V.N. Patil, my lord.
V.N. Patil. You have to give a day make distinction. Since you are referring this paragraph, you just explain us.
Yes, my lord. Will again, if I explain this, my lord, will again come back to, my lord, that very point, my lord, about error and lacuna, my lord.
No, not talking about this thing. About for this elaborate reason. It says every case it's not required to record elaborate reasons. We are not asking you to explain the reasons. In what case elaborate reason is needed, in what case elaborate reason is not
Of course, it is not clear, my lord, but at the end of the day, my lord, it is for the just reaching to the just decision of the case, my lord. And the last order.
How do you decide what is just decision?
Just decision, my lord, to collect the best quality of evidence, my lord, to reach to my lord finding.
And how do you decide that what would be best quality of evidence?
Definitely, my lord, whatever is not revealed before the court, my lord, if somehow, my lord, it can be, my lord, collected.
So it can be for even improvement of any evidence?
No, my lord.
So where is the distinction? Where in which point that distinction is to be drawn?
My lord,
can say, supposing after 311, as we say, that whether an evidence is essential or not can be decided at the time when it is recorded.
My lord.
Now, while recording, the court finds it not essential. Can the court say, no, you are not rated 311? Okay, see, 311 decision to summon or not to summon has to be taken up before evidence is recorded.
Yes.
So once the court takes a decision, that means there must be some materials before that court.
True, my lord.
Basing on which the court
absolutely
that it is essential.
Absolutely.
Now, what are those?
I cannot improve that, my lord, because I cannot go beyond, my lord.
Mr. Gurung, don't take it that way. It is not that. We are talking about the the legal aspect.
My lord, whatever has been recorded by the trial court below, my lord, I cannot go beyond that, my lord, because apparently it is before your lordship.
Understand. Now, another aspect, and just if we can throw some light. If one witness is examined, who is already recorded under 161. Now, subsequently, that witness is again sought to be recalled. Now, while recalling, can the court examine the evidence which is already adduced with section 161 statement and say that there is some deficiency, this person has to be recalled again?
My lord, here is a case, as per my understanding, my lord, it was not the court, but prior to that, my lord, the prosecutor had approached the court, my lord, that there is a necessity.
Well, the prosecution.
See, in your petition, there is nothing.
Nothing.
There is nothing.
There is nothing.
There is nothing. Now, the reasons given is 161 and the confession statement of the accused. So, this court fails to understand how that witness is connected with the confession statement of the accused.
It seems, my lord, I had submitted on the earlier occasion, my lord, of the record, my lord. Her statement before the court, my lord, was in contrast, complete contrast with her 164 statement.
Okay.
And later on, it was found that, my lord,
Okay. See, we can understand. You have told us already.
Yes, my lord.
That she has started residing with that husband. Okay. Hard parties. Order will come.